Is it? Good morning, it's still morning. Good morning, Ms. Mdhluli.
Good morning, DCJ.
Are you well?
Yes, I am grateful.
Good. Well, I'm well too. I see that you're not interested in my health.
Well, one time I listened to one candidate asked, and the reception was like, oh, she wants to know how I'm doing. And I thought, okay, let me not engage much.
Okay.
And instead respond.
All right.
But I'm interested. How are you, DCJ?
I'm very well, thank you.
Thank you.
You are a holder of 2 degrees, an LLB and an LLM.
Correct, DCJ.
From the University of Venda and Universities of Venda and Limpopo, respectively.
Correct.
Is it you who also has a diploma in theology?
Yes, that's me.
I see that you have not listed it. You were outed by some professional organization.
No.
Why have you not listed it?
No, it is part of my CV, DCJ. Even the certificate has been attached to that effect.
Oh, it has? Oh,
yes.
My mistake.
I think that's where you're remembering it from.
That's quite interesting. Why did you decide on that diploma?
Well, it's more like a response to a call, more than anything else. When you are in a particular field, training becomes very important for you to be able to trade well and sufficiently in a specific area. So I am a church leader, and I needed training in respect to that, hence the diploma qualification.
I see. You are an attorney by training.
Correct, DCJ.
And you were at the sidebar for how many years? About 7 years.
I was never at the sidebar. I've always been an attorney.
I thought attorneys are in the sidebar and advocates are in the bar.
Well, maybe it's because DCJ, we've got advocates who don't do pupillage, who are called sidebar advocates, and those who do pupillage are in the bar. Hence, I don't want to associate myself with that from the province where I come from, at least.
All right. I hear you. So you were a professional assistant for 2 years?
It's actually for some few months, because I was admitted in July 2008, and I left the firm in December, actually the end of November 2008.
To start your own practice?
Yes.
And how long did you do that?
Run
your own office, that is?
I've been in my own office from 2008, December the 4th to date. Well, save for the times when I've been acting as a magistrate, as well as acting as a judge.
Wait. Is it not you who act as a magistrate at some stage?
Yes, DCJ. I acted as a magistrate in the then Tabamopo Magistrate Court, now Leboa Khomo, as well as Magistrate Court Polokwane at some time.
For how long did you do that?
The total acting in the magistracy is about 40 months, with Tabamopo having more months than Polokwane. Polokwane, I think I was there for 5 months, and the remainder for Tabamopo.
All right. But then you went back to practice?
Yes, I went back to practice.
All right. In 2015?
No, in 2015, that is when I actually registered my sole proprietorship to an incorporated, hence then it then becomes, I was a director. Throughout, I was a sole prop. Yes.
I'm actually interviewing you based on the application, the JSA application, and it seems there's a disjuncture between it and your CV, but that's fine. We are getting the information we need. I'll carry on with the JSA application because that's what we are asked to complete.
Yes.
You have acted as a judge.
Correct.
Since July 2020. It says you're acting judge 27 July 2020 until October 2020. Is that accurate?
It's April 2020 to June. Again, May 2021, from July to September. Another period was the 3rd of May to June 2022, 29th October to 30th November, and lastly, 17th January 2023 to 17th February 2023.
Okay, I understand about the most recent stint. I'm just concerned now about the earlier ones, because as I said, I'm following the information you gave us in your application form.
Yes, the reason why on the form I did not include the October and June one is because I was acting doing a special trial that was continuing, and there was no appointment that was issued safe to take oath, and I was remunerated for that as well. So that is the one that was outstanding from the application, because the application was at the end of 2020.
Well, it still is an acting stint.
Yes, that was an...
you were finalizing a apartheid matter, not so?
Correct.
Acting as a judge.
Yes.
Being paid for it.
Yes, that's why I'm saying it was an error on my part that I did not include that in the form.
Yeah, but that's not my concern. I understand that. My concern is that the times, these periods you've given now do not tally with what is in the form, the ones that you have actually stated. Because you said you acted between 27 June and 30 September 2020, and then you listed 3 May until 30 June 2021, and you just gave me completely different dates now. But be that as it may, how long have you acted as a judge? Counting now the times that you say you did not take into account because you were finalizing apartheid.
I think it's plus minus 10 months, DCJ.
10 months.
Correct.
Okay. During that 10 months, what kind of tasks were you given? What areas of the law did you get a chance to dabble in?
The first 2 terms I was allocated the criminal trial court. Actually, I did the motion court this year from 17th January to 17th February 2023.
For the first time?
For the first time, yes. And I dealt with both the unopposed motion court as well as the opposed motion court, civil appeals, agent court. Oh yes, in the previous terms where I did mainly the criminal court, I also did some motion court minimally. There was a motion court week that I did, an agent court that I did, and 1 special civil trial. But being placed in the motion court, it was only for this year.
And how many times has that been?
Well, every day for the whole month of, from 17 January to 17 February 2023. So the entire month that I was acting in this year.
You were just in the
motion court, yes.
Okay. And you say you've done appeals as well?
Correct.
Both full bench and full court?
Correct.
Have you written any judgments?
I have not written any judgment. However, during one of the...
At all during all these acting stints? I'm not asking just about this term. I'm asking if at any time during
Yes, I did. Yes, I wrote
How
judgments.
many?
I think it's about 3.
Throughout the entire period?
Correct.
Any of them reported in the law reports?
No.
Okay. And I take it that 3 you've written are the ones you have attached to your application form?
Yes, they have attached to the application form.
So you've written only 3 judgments so far?
In the full court?
No. Altogether, during your acting stints as a judge?
About 16 written judgments. Those are the ones that I have.
Okay.
Yes. I thought we were still talking about this, the full court bench, because it was a follow-up after that question.
No, I'm sorry I didn't make myself clear.
All right.
I'm asking about all the judgments you've ever written as an acting judge.
I did not get that part.
Okay.
Sorry.
In which areas of the law were those 16 judgments? Can you recall off the cuff?
Yes. Actually,
it's fine if you can't recall offhand.
Yeah, I can't recall offhand, but some of them are attached to my application.
You've listed them at pages 11 to 13.
Thank you. Thank you. I'm getting there. Well, my page 11 to 13, it's about the matters I've done and not the judgments per se.
Or is cases in which, judgments in which you've appeared?
Yes.
Not written
Not
yourself?
the written myself, yes.
Okay.
But of the ones that I have attached, okay. There was one I dealt with, I think, with JP Mahoba about a lapse of an appeal and the reinstatement thereof. So, yeah. Yeah, the numbering has changed because of my index, but yeah. Maybe for now it's safe to say DCJ, I can't recall.
No, that's all right. I see that you have young ones. Your children are still quite young. The youngest was 10 months old when you filled in this form.
Correct. 3 handsome boys. The youngest now is 1 year, 3 months. Was born on the 17th of January, 2022. Yes.
You have not found having children whilst in what I hope is a busy practice challenging?
Well, I think that's it's a story of most of women in the profession, and I found that having supportive family members, a partner, assists greatly because the profession is quite demanding on its own. Now, when you go to the bench, it gets crazier because you are present and yet not available at times. So I found it very challenging. I was actually glad that at the time when I had my young one, I was not acting. And the time when I did the other periods were like October last year till November, at least he was now able to sleep at night. You know, babies, there are times where sleeping at night is a luxury. But at the time when I did that, he was a bit better. And now his schedule has changed, so I'm very able to cope. Yeah. I did even so, especially in the motion court this year. It has been one challenging period that I would not have made it without the assistance that I've received and the support from my family.
And to answer the question but I can assure you that, well, it has been my experience at least that it's easier to raise kids whilst on the bench because the work is more structured, unlike in practice where you are pulled from all sorts of directions. So if you are appointed, you'd have an easier run as a mother.
I believe you.
Yeah. All right. I will stop here for now, Ms. Mdhluli, and hand over to the rest of the commission. AJP Simenye, do you have questions for this candidate?
Yes, thank you, DCJ. I see you have studied in Venda.
Correct, AJP.
And you have never acted in the High Court
there? Yes.
Have you ever appeared in that court as a practitioner?
I've not appeared as a practitioner in that court, but I'm familiar with the court.
You are familiar with the court?
Correct.
As I agree that you were only allocated the motion court this year, and it was after you have handed in your application, and that for that reason you didn't have any judgment in that field.
Correct.
At the time you were making this application. DCJ? But now I have searched through SAFLI.
DCJ, we
can't hear me. Oh, sorry. I have just searched through SAFLI, and I realized that the last 4 judgments for March are your judgments in motion courts. Did you, after writing that judgment, read it and proofread it? Because I found that most of them had sentence construction were not correct. The way you went through the facts is also not appropriate. And I feel for that reason that you should be granted more opportunity to act in the motion court as well. Do you agree with me?
I think if the AJP could assist me in terms maybe of reference to probably which judgment you're referring to.
All last 4 judgments on SAFLI for March.
Okay.
For March,
so
yes.
All of them?
All of them, yes.
I find it rather puzzling, but I have proofread it. I type my judgments. Nobody types them for me. I type them. I proofread them myself. So, as for your observation, I think it's regrettable. I accept it for purposes of now, since you are not able to
refer me. This was your first stint, I agree, in the motion court. I agree with that you did not have much opportunity to preside in that court. And further than that, I did an criminal appeal with you. And you were the scribe. And I must say that it took me, I had to, the first judgment that you wrote and gave to me, I read it and I had to do much work on it. And this is not only me who's saying that, there are other judges who are also saying that they have to do much work to correct the judgment that you have written. And I also believe that in that field as well, you still need more time to act in that, on appeals as well. Do you agree or don't you agree with me? Because it's not only me. Last week, one of the judges was telling me about one of the judgments that you wrote and handed it over to her so that she can sign if she agrees with you. Well,
I think AJP It's surprising, I think, because I remember the judgment that you and I sat on. And you corrected, it's just that I don't have the judgment with me, but I keep all the records of my judgments, especially the ones that I'm sitting with other judges, so that for my recollection, I know where I fell short and where the contribution has been. And if I recall the judgment that AJP you are referring to, is the judgment of Dibila, wherein I think your contribution was to the extent of structure to a certain extent, and also you asked me to include a particular citation of a case. And I remember very well in that judgment, AJP, that you were not even in the first instance agreeing with my conclusions of that judgment. And when I insisted on it, you undertook to go and read again. And when you came back after reading, you said, indeed, you were right.
Yes, I agreed with you at the end after going through it again. But I'm actually on the structure. The way you have written it and the way you have structured the paragraphs. And remember that I also said to you, if you decide to write a judgment in such a way that you put headings on it, make sure that under that heading you deal only with what you have said it is on the heading, and not to say this is the heading, but touch on other things as well.
I remember that.
You remember that?
Yes.
I'm talking about the structure only.
Yes, I think if I can continue, because you referred to the other judge as well, and I think that would be that would be Judge Nodie Odendal, which I wrote a judgment in which she was involved in the civil court. And I can tell you, I even have the judgment with me in this building. The structure or her contribution to that judgment was with respect to italize court accrue as well as put in paragraph numbers. I have that judgment with me. And that was the only thing she said to me. So I find it very puzzling that she was able to say that to you and yet not to me when she was sitting with me in the very same court.
Okay, I thought she has discussed it with you.
No, it was not. That's what I'm saying. It's very puzzling.
Okay, I'm sorry about that. You have made yourself available for Thohoyandou High Court.
Correct.
And you are aware that there are only 3 judges at town. You are going to be the 3rd judge if you are recommended and the president signs. And as a result, we don't have the luxury of working in only one court. If you are allocated criminal cases, you may at any time be given a civil trial to do or be asked to do in the annual post and so forth. Are you able to tell us about the incident that happened this year when a senior judge allocated you a file to do when you were not in court on the day? Do you remember what happened?
Yes, very well, AJP. I remember the events very well. I was in chambers busy reading my files for the annual post court for the following day, and Asha came into my chambers with a file and say, I was told to bring this file to you, and I asked, what is it for? And she said, no, they will come and tell you. She left. After some few minutes comes the Judge MG secretary to say, here's the file, they say that you must attend to it. And I asked, why are you not attending to it in your court? Because this is your court matter. And she said to me, they are still busy with something else. And as she left, I thought to myself, okay, I don't know how things should happen. Let me go and find out from the AJP's office. When I came to your office, I actually found Judge MG Patudi complaining to you about me not having received the file. And I waited for him to speak. I think there was an opportunity for me to respond because there was some sort of misrepresentation that was happening there. And I said, no. I came to understand, is this how things are to happen? that a judge who's sitting in court can send a file without any a discussion with me, because my understanding was that as much as I was acting, I'm still a judge, and as a colleague at the time, should there be any request for relief, same should be communicated to me as a judge. But then again, it was yourself who said to Judge M.G. Podu that no, what you did, yes, we agreed about it in the meeting that I was not invited to. If you recall, that meeting that you had in January, I was not invited to that meeting, and you are aware of it. There were resolutions that were taken in that meeting that they were not communicated to me. And you said, yes, we agreed in that meeting, but we agreed that that decision, or the decision to take the matter or the file to another judge, must be done through your office as the AJP to avoid abuse, especially of acting judges. And same was not done. And then from there onwards, you elected to proceed with the matter yourself. I think that is the events of that particular day.
I fail to understand that.
AJP, sorry, before you carry on, I think we may be running into slippery ground now. Questions are being put to the candidate about what may be transgressions, and practice is that if a candidate is going to be asked, questions that you know, questions similar to the ones you are putting now, they are given forewarning before the interview. They know to expect, you know, sorry, they know what to expect will be put to them, and they can prepare for that. They can even submit answers before the interview itself. Now, questions are being sprung on this witness, and none of us were given any hint that you'd be put. Well, I hope you did give a forewarning, even if orally, but the commission sitting here was certainly not aware that you'd bring this material in the open here. So there may be a big problem there.
I understand, DCJ. I withdraw the question.
All right. Thank you.
I have no further questions.
Thank you, AJP. Commissioner Malem?
I just want to ask one question, DCJ, to Ms. Mdhluli. Do you think you've got the right temperament of a judge? It's a question. Oh, sorry.
Thank you, DCJ. Good afternoon, Mr. Mdhluli.
Good afternoon, Commissioner.
Traditional leadership is a strong and important institution in Limpopo. We have almost 200 traditional leaders here, including kingships and the queenship. You've said that you've acted for a period of approximately 10 months with 16 judgments. Have any of those judgments related to traditional leadership?
Unfortunately, I have not been presented with an opportunity to preside over any traditional issues, matters before me during the time when I was acting. So none of the judgments that I referred to relates to that.
No, thank you. May I take you to your questionnaire at paragraph 9.4 on the question, have any of your judgments been taken on appeal? Indicate with an X, and you said yes. And the following question was, what was the result of the appeal? And your response was, leave to appeal granted only as at the time of this application. The appeal is not yet heard. Perhaps tell us, if you can remember, what is the name of that judgment which was taken on appeal?
It was the Klassen matter.
Okay.
It was a civil matter. It was a Klassen matter. And from what I've heard, the appeal has been successful in that particular matter by SF today.
No, thank you. Indeed, it is Klassen's matter. Johannes Klassen was appellant, and Marupini Franz Nakana, first respondent, Minister of Police, second respondent, and Warrant Officer Williams, third respondent.
I'm sorry, Mr. Singh, I don't know about the other commissioners, but I am struggling to hear you.
Okay.
I'm also struggling to hear him as well.
Okay, I'm going to speak a little bit into the mic, DCJ. Yes, indeed, it was the Johannes Klassen's matter. It's a civil matter for unlawful arrest. What perturbs me is this. Your application was submitted on the 29th of November 2022. You heard the case on the 21st of January 2021. Leave to appeal, you granted leave to appeal, and then the appeal court, chaired by Judge President Makoba, Muller, and Acting Judge Zitole, delivered judgment on the 16th of August 2022.
Yes, I was not aware of that at the time. I became aware when I was busy preparing for the interviews. I engaged with actually my secretary as at the time, who assisted me in that information. So I did not know at that time of the submission of the application.
Mr. Mdhluli, you were submitting an application to be appointed to the bench. I would have thought that you would have taken care in the information you supplied to this commission. How do you respond?
Yes, I think I've said that at the time when the application was submitted, I was not aware that the appeal had been successful. Hence, I volunteered the information now without you even asking me that because you asked if at the time it was outstanding. I said by now it was successful.
No, fine. Okay, two of your orders were set aside on appeal. The first one, okay, before you go to the first one, what also concerns me is that your first order in a civil case read, and I'm quoting, the defendants are guilty of unlawful arrest and detention. This being a civil matter. Is it not a fundamental error to find a defendant guilty in a civil matter as opposed to liable?
Yes, I think the use of the word guilty could be confused for criminal court language and not suitable for the civil court jurisdiction.
Okay. I mean, fundamental errors like this does not provide the confidence needed. But the confidence needed.
I did not get the first part of your
fundamental errors like this is my comment, does not provide the confidence needed to recommend a candidate for appointment to the bench. What is your comment?
Well, I think that for me would be a fair comment. However, I think the Commission should take into account that that was the first judgment that I wrote during the time when I was even apportioned the criminal court role. So there has been great, I think, improvement from then onwards to date, and I don't think I've ever repeated that type of language use error since then.
Thank you. My final question to you is, given the fact that you don't have any traditional leadership experience at bench level, given the fact that your forms are not in order, information is incorrect, how would you respond to the message or to the remarks by the Limpopo Society of Advocates at point 29.1 of the comments on your application? I will read it for you. It will not be an offense if the candidate was to be given more acting stints to gain more experience before she can be appointed permanently as a judge. The bench needs to have judges with all necessary skills. The bench to appoint her will not send a good message to society at large.
Yes, I have seen that judgment, that observation or that conclusion by the society. However, when I read through their comments from the first page going down, it's as if I knew what the conclusion would be at the end. However, the content of the motivation or the objection does not really resonate with the finding, which is that I should not be recommended. Now, acting further definitely cannot be taken away that it will enhance me as a person, and equally, should I be appointed, that will also work for me because I will be sitting daily in that court, being exposed to the matters that appear before court, and I will be able to discharge the duty that is required of a sitting judge. Now, as far as the traditional affairs are concerned, I am born and bred in the village. I lived and I continue to live traditional affairs. I know it from my livelihood experiences, and I'm familiar with the dynamics of the traditional authority, and I'm also familiar with some of the cases that are going on in our country. And also, should the traditional matter appear before me, I will not take it from a position of the law only and the facts before me, but also the fact that I'm conscientized as far as the traditional affairs are concerned. That would assist me greatly as a village girl, for lack of a better word.
Thank you, DCJ. That's all for me.
Oh, thank you very much, DCJ. I have one question. The one I asked earlier. Do you think you've got the right temperament for a judge?
I think I do, Commissioner Malema. That can be seen or observed through my judgments, how I conduct myself in court, how I relate with professionals, practitioners, as well as the stakeholders that are involved even in the running of the court, how I relate with my colleagues. And this comes also from not only now as a judge, but even professionally. I believe I have that good or right temperament to be a judge.
What is your witness? It can also be a witness not knowing your witness.
Yeah, not true that. Because I'm actually thinking that my weakness is my weakness is always trying to make sure that things work the best possible way, even when they are not within my power. That's my weakness.
Thank you, DCJ.
Thank you, Commissioner Malema. Commissioner Marumokai?
Thank you very much, DCJ. Good morning, Mr. Mdhluli. I'm this side.
Good morning, Commissioner.
Look, I think the issue in relation to the grammar and formatting of your judgments is an issue that should have been raised with you at the division level and be addressed with. And there might be concerns relating to that, and I will make my submissions during deliberations. But I think it is something that you need to really take to heart. I understand that the language of record is not necessarily our language. And sometimes there might be a greater need for us to really edit the judgments that are written. And I'm speaking from somebody who writes for a living, right? That there are mistakes that can be made. And I'll just give you one example of such mistakes. And these are things that can be corrected. I don't think these are things that you can really be angry with. In the judgment that you penned, just trying to see, it's very difficult on Safi to give a citation, but it's TKM on behalf of KKKYKKKM. Do you remember that matter? It dealt with the applicability of interim orders.
Yes.
Yes. In the first sentence of that the first paragraph of that judgment, you write, children are the world's most valuable resources and its best hope for the future. Full stop. Then you say this code, it's not a code, it's just a sentence. Then you say this code ran through the judgment, which leave is sought on and will be running through the spirit of the judgment. And I think that is the concern that is being raised, and that you should actually take to heart and really work on. I don't think it's a criticism that is destroying. It's a criticism that is building. That please take care when you are writing, because these are going to be, and this judgment it has similar sort of mistakes. Because I'm raising this because you were saying perhaps we are not directed to those kind of issues. My last question that I have for you, and that was just a comment. The question that I'm having for you is, in this judgment, you correctly say that generally interim orders are not appealable or are generally not appealable against, right? But there are circumstances under which they can be, and you try to list those. Can you just please explain to me what are those circumstances? Under which circumstances can interim orders be appealed against?
I think one of those is when the interest of justice demands that they should be appealed, because the courts, it's tried that, especially the SCA, warns us against taking matters for appeals on piecemeals. So if the interest of justice requires that the interim order should be appealed, same should be done so.
Thank you, DCJ.
Thank you, Prof. Deputy Minister Jeffrey.
Thanks. Good afternoon, Ms. Mdhluli.
Good afternoon, Deputy Minister.
Mine is a question on substantial and compelling circumstances to deviate from minimum sentences for rape. What would you regard as substantial and compelling circumstances?
Those are usually dependent on...
Sorry, DCJ. Sorry, DCJ. The sound seems to be quite faltering. We couldn't quite hear the Deputy Minister's question. Sorry to interrupt.
All right.
Okay, just quickly to repeat, the question was around what are substantial and compelling circumstances to deviate from minimum sentences for rape. I hope that was audible.
Can you hear him now?
Thank you. That's good. DCJ.
Thank you. I was saying, Deputy Minister, that those are usually dependent on a case-to-case basis, because our case law has taught us that as much as the legislature has prescribed minimum sentences to certain offences, it did not prescribe what those are, and it left it to the court to find what would be compelling and substantial circumstances. And our case law also goes on to tell us that in terms of compelling and substantial circumstances, one does not have to look at something that is very out of the ordinary to the normal mitigation principles or circumstances that we look at. For example, I will give, and it does not make it, I must not be confused to be saying it makes it less of a rape, but in circumstances where you find that there was no penetration of the genital, for example, maybe where a person uses their tongue for raping, it is still rape, and it may also depend on the circumstances of what happened in that particular instance, where you find that this was parties who were consenting, but by the fact that that particular party was a young child makes it rape. Could be one of those compelling things. So in my answer, I would say they are dependent on case-to-case basis, but it's nothing out of the ordinary of what we normally deal with.
Are you aware of State versus Matiti the 2011 case from the SCA on minimum sentences?
Yes, I recall that.
Yeah, I mean, that judgment was a little bit harder or stricter, as I would read it, on the concept. But just out of an example, for the rape of a child, would you say that the relative youthfulness of the accused, well, any of these factors, relative youthfulness of the accused, that his mother testified that he was of good character, that his girlfriend testified that he was of good character, that he expressed remorse. Would you say any of those are substantial and compelling circumstances in your view?
Under the circumstances that you've alluded to, no.
Thank you.
Thank you, Commissioner Lucas.
Thank you very much, DCJ. Good morning, Ms. Mdhluli.
Hi, good morning, good day, Commissioner Lucas.
Thank you. It's good to see you here, a young woman with a bit of energy.
Thank you.
So, but I see that you have a practice as a lawyer, and you are aspiring to become a judge. And I've listened to those that have been judges before, asking you, how do you juggle your program? I just wanted to, directly to your firm, wanted to ask you with regards to what programs you have in regards to social responsibility, and also how do you contribute to making sure that you actually mentor other young black women by using the resources that is at your disposal. That was my question. Thank you. Thank you.
Thank you, Commissioner. I think for those that live and work in Limpopo know that I am a mentor to a whole lot of young females, including males from the student chapter of both the BLA as well as Saul. I also mentor young women in the profession. Now, from my law firm, I've had over all the years when I do articles, always make sure that women are taken as a priority. And I, amongst other things that I do, is to annually have events that are organized by my practice in the communities wherein there's legal education that is provided freely, including some activities, with the latest one being a celebration of Women's Month just last year in the village called Rasiminya Muleji. It was a day filled with aerobics, activities, t-shirts bought for women. Thereafter, there was legal education that was provided. But it does not only end with only the female commissioner. I do that even amongst several communities through the tribal authority, meetings that I make arrangements to and request that I come and give legal education to communities, as well as different and several churches, of which most generally church attendants are women. That is amongst other things that I do.
May I have a follow-up? So my follow-up is just in two ways. You said you are a pastor, and it's actually a very good thing. How does being a pastor assist you in your work as a judicial officer? That is the first one. Secondly, customary law. You say you are doing legal training and things of that. What kind of programs do you have around the whole issue of customary law? Particularly since you said you are a village girl, like you put it, and you grew up in a traditional community. Thank you very much, DCJ.
Thank you. I think the element that assists me in the judiciary from the pastoral side is dealing with people with compassion. That is the element that assists me in the judiciary. Now, with the issues that are customarily based. When you go down to the communities, the cry that our community members have is that they feel that the courts do not understand their plight or does not resonate with how the people live. For example, I'll give, in terms of customary definition of a marriage, lobola is not part of the essential elements of the definition of a marriage. However, in our different communities, it's a very big deal when lobola is not paid in full. Actually, our gogos and our mkolus don't believe that you have married when lobola has not been paid in full. So, amongst other things, when you educate the communities to say, if you go send delegates to a particular girl's home, you pop out some money, there's an agreement there. Legally, you are married. So you don't have to wait for that particular day when the celebration is going to happen and things like that. And those are some of the things that they have challenges with, amongst others.
Thank you.
Could I just follow up this question of customary law? With your permission, Deputy Chief Justice. Thank you. Good morning, Judge Mdhluli.
Good morning.
Yes.
Commissioner, it's still Mrs. Mdhluli.
All right. Well, yeah, sorry, not judge. Okay, that's fine. Acting judge.
Well, at the moment, I'm an attorney. Thank you. Right. I'm not sitting at the moment.
All right, Ms. Mdhluli.
Thank you.
Yes. So you are sitting as a judge, and a case comes where there is a contested rule of custom. Just tell us what steps you are going to follow to resolve the contestation on the rule, and give us the maybe 3 leading cases.
Well, I always start with the Constitution as a point of departure and see that whatever dispute that is before me, does it fall or that it passes through the constitutional master. Thereafter, I will go to the common law that is applicable to the parties that are before me in dealing with customs.
No, sorry, I should stop you because I think this is going to take a long time. This is not a dispute about the Constitution. It's not a dispute about the common law. It is a dispute about a rule of custom. What I'm asking you is what are the legal rules you will apply to resolve a contested rule of custom, and what are the legal cases that are leading?
I think I'll first employ common law as a point of departure on that custom, unless I'm not understanding you, Commissioner.
No, thank you.
Follow up, DCJ. Ms. Mdhluli, I got interested when you started talking about lobola and all those, but I want to ask you on that question, but asking you not from the community's perspective, the views of the communities, but from a legal perspective, and asking you as an attorney and an aspirant judge. When you are faced with a dispute, a marriage dispute, where one party is saying, I'm not married to this person, and the other party is saying, we married in terms of customary law. And the issue before you is divorce, but before that is the declaration of the validity of the marriage first, right? As is usually the case. And it appears that the Recognition of Customary Marriages Act, Section 3, the requirements are met. As in the age of the parties, they are above 18. The marriage has been consented to, and it has been celebrated and entered into in accordance with customary law. All those requirements, in other words, the official requirements have been entered into. But what is in dispute is the living requirements, in other words, the customary law requirements. What are those customary law requirements which are not in the Recognition Act, which are applicable, especially for the communities that are in the bench where you are actually applying to?
Well, one of them would be the handover of the bride, wherein the bride is officially handed over to the family of the husband, and they change also the surname, because until in some communities where the surname is not changed, other people don't take that as a marriage, even though they accept for some who are professionals who may retain their maiden surname or double barrel. So those are some of the not listed elements that are there in terms of customary in our communities.
Thank you, DCJ.
AP Betty?
Thank you, DCJ. Good afternoon, Ms. Mdhluli.
Good afternoon.
The question that I have to you has to do with one of your judgments in William de Pella versus the state. And I have a few fundamental problems with that judgment. Your paragraphs 1 and 2 tells us what the charges were and that he was convicted. Then paragraph 3 says that the appellant is appealing against both conviction and sentence on both counts. And the next sentence, which is contradictory, says the matter is before us on automatic review in terms of Section 309 of the Criminal Procedure Act.
Yes,
Did the matter serve before you on appeal or on automatic review?
It was before us as an appeal. It's actually the matter that the ADJP was referring to where we sat together. So it was an appeal.
Thank you. Then for the most part, your judgment traverses the evidence, and ultimately you conclude that the state had failed to prove its case beyond reasonable doubt on count 1, which was rape, but that the conviction on count 2, which was assault, was unassailable.
Correct.
But what I find puzzling is that then in your final paragraph, the order, of course, upholds the conviction in relation to the count of rape, set aside the sentence. Then paragraph 2 confirms the conviction on count 2. Then you set aside the sentence of 3 years that had been imposed by the trial court. And there's nothing in the text of the judgment to indicate how you came to the conclusion that the sentence failed to be set aside. Are you in a position to comment on that aspect before I proceed to the next?
Yes, as I look at the judgment, Commissioner, you are correct that I have not said anything with regard to my increment of the sentence therein. However, the reason why...
I'm sorry to interrupt you. I'm not there yet.
Okay.
You set aside the sentence.
Correct.
But the judgment itself doesn't tell the reader what you took into account to arrive at that conclusion.
From my brief look at this, I don't see it at the moment. You're correct.
Okay, let's proceed. Then the other fundamental difficulty I have, the trial court had imposed a sentence of 3 years, which you set aside, and increased, then you increased the sentence to 5 years
Correct.
And you say nothing about whether the appellant had been forewarned or whether there had been an appeal by the state, because there are judgments of our court which says that the appellate court, it is not competent for the appellate court to increase a sentence when there is no appeal by the state against the sentence. There's one which I wrote at the SCA 2015-16, which was confirmed by the Con Court a year or two later. Do you have any response to that?
Correct, Acting President. When I increased the sentence at the time, I took into account the gravity of the assault GBH that was perpetrated against the complainant in the matter.
But you accept that there was no appeal?
Yes, I do accept.
Against the sentence.
I do accept that there was no basis for that laid in my judgment, Commissioner.
Thank you. Thank you.
Could I just follow up on this question? Because I actually noted that judgment. But my understanding is that you were actually sitting with a senior judge who's the president of the division in that very case.
Correct.
Commissioner Nyambi?
DCJ, thank you. My colleagues have done justice, so it won't do any harm for me to say I'm ready, I'm covered for the next candidate.
You won't follow suit?
DCJ, since I'm instructed, I'll follow suit.
I'm not instructing you to do anything, please. All right. Any further questions, colleagues? Any questions from the virtual platform? No. All right. We have reached the end of your interview, Ms. Mdhluli. Thank you very much for making yourself available. I wish you all the best. You're excused.
Thank you for the opportunity and for the hearing. Thank you.